In Chapter 5, we will address the issue of civil liberties. These are protections from the U.S. government. Unlike civil rights, most civil liberties are listed in the U.S. Constitution, and we tend to think of them as individual grants of protection from the U.S. government. The Bill of Rights, where most of these are located, are the first 10 amendments to the U.S. Constitution, and they took effect on December 15, 1791, after being ratified like any other amendment would. There are three other civil liberties that are significant that are in the Constitution but not in the Bill of Rights. These are habeas corpus, or your protection from being imprisoned without hearing the charges against you and having a judge determine whether there's at least a small amount of evidence to hold you. No bills of attainder. Bills of attainder are laws passed by Congress that authorize the imprisonment of you for being you, not for any particular law that you violated. And in fact, it's often treated that these mean that that a crime can't be created specifically for one person. And then no ex post facto laws. Ex post facto laws are laws that criminalize past behavior. So if you did something that is illegal, then of course you can be convicted. And if there's something that you're doing that's made illegal, you then have to stop. But the protection against ex post facto laws is the protection against laws that criminalize something and say, well, you can't undo what you've already done, so you're guilty. So the issue of civil rights and civil liberties in the Constitution it can be complicated. The people who founded the United States were not so much against their existing civil liberties. Rather, what concerned them was that if you listed civil liberties in the Constitution, that might come to be thought of as an exhaustive list. The framers believed that the Bill of Rights wasn't necessary because if the government institutions were properly created, they would have conflict against each other and they would limit each other's powers. States could protect us from the national government, and the national government from the states, and Congress from the president, and the courts from Congress and the president, and so on. But others believe that that the main reason why you didn't want to do this is that it implies these are the civil liberties. And, in some ways, that is in fact true. When we look at the civil liberties that are in the Constitution, and somebody says, well, what about my right to earn a decent living? And they're like, well, that's not in the Constitution. And that becomes a limitation. But it also provides a lot of great protections. Also, the Bill of Rights did not initially apply to the states. The Constitution was thought of as only covering the national government until the passage of the 14th Amendment. Your protections from state action were seen as an element of your state constitution. However, the 14th Amendment's Due Process Clause is the justification for applying the Bill of Rights to the states. The Due Process Clause says that no state can deny life, liberty, or property without the due process of law. We've talked about that a little bit with civil rights because it's an element of your civil rights. The national government is going to defend your liberties. The application of the Due Process Clause is called incorporation. Incorporation, though, is not automatic. In fact, the term incorporation is nowhere to be found in the Constitution. We see that the Supreme Court at first was very leery of advancing this idea. In the slaughterhouse cases in the 1870s, the Supreme Court said that the 14th Amendment was only to protect African Americans, and others had the same rights as before. And the same rights as before meant that the states didn't have to be limited in any way. A famous case, or maybe you've never heard of it before, but a famous case for people who study constitutional law is Palco versus Connecticut from 1937. And I'll tell you straight out that if they misspell your name, because the guy who was in the case was actually named Palka, yeah, but they said Palco and they never bothered to change it. That's usually a bad sign when you're in front of the Supreme Court. It was a guy, he had robbed a store, and his accomplice had shot someone as part of it. And when he was convicted of first-degree murder, well, at first he was not convicted of first-degree murder, he was convicted of second-degree murder, but the state decided to bring the case again so that they could convict him of first-degree murder this time. And he said, well, wait a second, I have a protection against double jeopardy in the Constitution. And the Supreme Court said, no, that was just a mistake the judge made, and that's the only reason why you were convicted of second-degree murder instead of first-degree murder. And double jeopardy only applies against the national government. We haven't incorporated that as a due process yet. And what gets what gets accepted here in 1937 is the idea of selective incorporation, meaning that only when they're very critical civil liberties in the eyes of the court will we see an incorporation of the Bill of Rights. Now, over the years since then, the Bill of Rights has been incorporated in many other instances. So I would say that today, despite the fact that we still have technically selective incorporation, almost the entire Bill of Rights has been on a case-by-case basis incorporated. The most recent of these is the individual right to own a gun, which was incorporated only in the 2010s. There's several different types of liberties or different ways that we can conceptualize liberty, but one way that we might divide it is between substantive and procedural liberty. Substantive liberty are fundamental and intrinsic liberties that are implicit to the very concept of liberty. And so we might talk about things like freedom of speech and freedom of religion. And we might say, well, they aren't just liberties because they're listed in the Constitution. They're liberties that are within our nature to have. And the Constitution is just stating that they exist. But other liberties exist not so much because they themselves are important. The freedom to have an attorney in a court case is not there because the Constitution sought to protect the ability of a lawyer to get a job. That it's not that you needed a friend to talk to and everyone had a right to it. Rather, it's a procedural liberty. You have an attorney so that you can protect your broader concept of liberty. They'll be able to tell you, well, you don't need to speak right now. If you say this, it might lead to your imprisonment. And so in order to help you, you have the right to an attorney, or you have protection against double jeopardy, or so on. These are considered procedural liberties, and if other procedures could be found They might not even necessarily be in the Constitution at all. However, they're to protect the concept of liberty by forcing compliance. Now, I'd say my favorite of the constitutional amendments is the First Amendment. The, the, the First Amendment establishes six important political and intellectual freedoms, right? The Establishment Clause says that Congress can't establish a religion that we would all have to follow or at least support. The Free Exercise Clause goes a step farther and says we have the freedom to exercise the religion of our choice. Sometimes together these are taken as freedom of religion, but the Constitution never uses the term freedom of religion. The Free Speech Clause gives people the freedom to speak without worrying about their imprisonment. The freedom of press gives right to, in essence, for people to engage in writing about things that they know related to the government. The freedom of assembly gives people the freedom to get together, and it's sort of a freedom to protest. And the freedom to petition is the freedom to tell government what you want. You might think of this as the freedom to lobby or to try to influence the government. Now, there's limits to freedom of speech. We've talked before about probably the biggest limit to freedom of speech, which is that it's a protection from the government. So if you say things that offend your employer and your employer isn't the government, well, you stand a really good chance of losing your job if you wear a meat is murder button to work and you work at McDonald's. You're probably going to be asked to take that button off. And if you say, I have free speech rights, your boss will say yes. And you can go and speak that somewhere else, but you can't work here anymore. But other limits to freedom of speech often involve things like how far can you go when it comes to giving a speech to a crowd? Can you incite a riot? Can you incite illegal activity? And the Supreme Court struggled with this in early years, often related to anarchists or communists who were seeking to incite people to change the government. Schenck versus United States was a case where the clear and present danger clause, or the clear and present danger doctrine, was first spoken about. Schenck was trying to keep people from registering for the draft during World War I, and by 1919, when the case came before the Supreme Court, the war was over, but he had been imprisoned, and this Supreme Court said, yes, it's right that you can imprison this person because a limit on freedom of speech is when your speech creates a clear and present danger of violence or rioting. Gitlow versus New York is when the free speech was first applied to the states. You see, Schenck was a case involving someone violating U.S. law. Dennis versus the United States limited a little bit, made it a little bit easier for government to imprison people for inciting violence. Dennis was a communist. People often like to limit the power of communists. However, in recent years, we see that it's much more difficult to say somebody says something and therefore you're allowed to imprison them, no matter what they say, unless what they say leads directly and inevitably to violence. Now, incitement to violence is not the only limitation on freedom of speech. A couple other limitations that are very notable within legal cases and things involving the First Amendment are one, obscenity. Obscenity is usually we're talking about sexual matters, things that are offensive or disgusting by accepted standards of morality and decency. And these can be works or visual or even written that tend to lead towards what society is viewed as being perverse. Slander and libel are two other instances. Slander being the verbally saying something that just isn't true about someone else, that tends to defame them or make them look bad. Libel is when this is written. In some respects, freedom of religion in the United States is a bit of a misnomer. We have two clauses in the First Amendment, the Establishment Clause and the Free Exercise Clause, that tend to work in tandem, and we can view it as a freedom of religion. But the actual words freedom of religion aren't there. In fact, one of the key provisions of the First Amendment might be thought of as a limitation on religion. Government can't establish a national religion. And this has been interpreted to mean that government can't even promote religion generally. Now, what exactly that means is something that gets fought over constantly. For instance, can religious images be shown at on a government building at Christmas time or at other significant times of the year? And sometimes, frankly, the Supreme Court has said yes, and other times it has said no. And perhaps the goal is to keep people unsure so that they're being very careful. Prayers at school graduations, things like this have been issues where government has actually been very limited in how it can promote or do anything that can be seen as favorable toward religion. At the same time, government does not have the power to prohibit the exercise of religion. Now, there's some exceptions here. If your religious practice were to somehow impinge on the rights of others, then there has to be this balancing between what your religion is asking you to do. Certainly, no one would say that the right to human sacrifice is protected, though that could plausibly, be what some religion somewhere would be in favor of. But government can't prohibit things such as religious worship, although this led to a great deal of struggle during the recent problems with coronavirus and whether churches could be closed in order to promote public safety. One of the main issues has always been the concept of entanglement, the question of whether there should be a wall of separation, as Thomas Jefferson once said in a letter. It's kind of humorous to me. It's not in the Constitution, but it's one of the more famous images that we have on exactly what freedom of religion means, that there should be a separation between church and state. Jefferson, of course, one of our most famous presidents, and the Declaration of Independence guy. It's not out of the blue, but he wasn't speaking as a person in government when he wrote of the wall of separation. Now, the Fourth, Fifth, and Sixth Amendments are not really designed to help criminals, but they are protections for the criminally accused. They're designed to keep government from infringing on the liberties of everyone. One of the examples that we've mentioned a couple times already is that there's a prohibition on double jeopardy in the Fifth Amendment, which means you can't be tried more than once for the same crime. Now, you think, well, how exactly is that good? You might have somebody who's acquitted and they obviously did it. We think of the late O.J. Simpson, who killed his wife, and then he wrote a book and said, "This is how I would have done it," without any fear whatsoever that someone would go back through and trace how he would have done it to see if maybe that's how he did it. And the reason why we do that, though, is because we don't want the government to just keep putting us on trial again and again until they get the outcome they want. Remember, no matter how wealthy you are, the government is wealthier. The richest guy in the world is not a trillionaire, but the U.S. government spends more than $1 trillion every year. So the U.S. government could bankrupt anybody. So we need to be give the government one shot at everybody. It's kind of a limitation on the power of government to continue to persecute us. And many of these protections for the criminally accused are the same thing. Why do we have the right to remain silent when maybe we know something? Well, because we don't want the government to just be able to torture us or threaten us. The protections of the criminally accused are very important. I think we'll mention them individually here. In the Fourth Amendment, it says that there should be no unreasonable searches or seizures, and no warrants should be issued without probable cause. And the Fourth Amendment typically discusses the rights of the criminally accused in their first interaction with the police, when the police seek to search. The video that we have associated with this module talks a little bit about this. The Fifth Amendment is really a grab bag of many different protections for the criminally accused, and this is at the point of investigation. There's some elements that are related tangentially, at least, to the trial, but for the most part, we're talking about the gathering of evidence. And things like requiring indictments, no double jeopardy, no self-incrimination, that you get due process, which in this case means that proper and normal procedures need to be followed. And takings can only be with just compensation. The Sixth Amendment deals most specifically with the procedures under which trials occur. You get the right to a speedy trial, a public trial, an impartial jury, trial in the state and district where the crime occurred, be informed of the nature and cause of the charge. You can confront witnesses. You can compel witnesses to testify on your behalf, right? Somebody can be forced to testify on behalf of the government. Well, in a criminal case, people can be compelled to testify on behalf of the defense as well, and your right to an attorney. How are the rights of the criminally accused enforced? And many of these elements that we're about to talk about are very famous, but surprisingly to some people, they're not in the Bill of Rights at all. They're just judges have made up these rules in order to make sure that they're enforced. The first of these is the exclusionary rule. If evidence is found against somebody in an illegal search, then whatever's found is excluded from the trial, or at least the case can be made that it should be excluded from the trial. This has a great effect, right? Normally, if you just said, well, a police officer can be put in jail for illegally searching or illegally questioning someone, then the police officer might say, well, that's worth it. This person is so horrible that I'm willing to go to jail, that they would go to jail too. But by making the exclusionary rule something that says if you do it wrong, then you can't use it, this forces police officers to seriously consider the costs and benefits of any time they would try to violate someone's rights when it came to obtaining evidence. The Miranda warning extends this to police questioning. You have the right to an attorney, and you have the right to uh, be informed of your right to remain silent. And so, if you're not told that you have the right to remain silent and the right to an attorney, then anything you say will be excluded from evidence. And then finally, lawyers have the right to go in front of judges before the trial, before the jury's there, and make motions to exclude evidence that's illegally obtained. The Bill of Rights also includes the Eighth Amendment. The Eighth Amendment has three provisions. It says that there can't be excessive fines or excessive bail, and that cruel and unusual punishment is not permitted. The big question, of course, we have is what do we mean by cruel and unusual punishment? We know at the very least that the death penalty is not cruel and unusual punishment in all cases. Now, the Supreme Court has limited the application of the death penalty to just cases involving murder. Sort of this idea of an eye for an eye, or a measured response, right? If somebody commits a crime less than murder, why should they be killed for it? I guess. But they've also been very conscious of things such as minimizing the amount of pain that the death penalty causes. I've always found that a little curious, right? The idea that, um, that a few seconds of pain versus a long, long time of death. However, the Eighth Amendment does not outlaw the death penalty. In fact, at such times as the death penalty has been ruled unconstitutional, it's always been for its unfair application, not that it would be applied at all. Excessive fines and excessive bail, they make sense, right? Don't charge too much given the crime. Everything should be proportional to the crime. Another important idea we have is the idea of privacy rights. Mostly privacy rights have been made up by judges. I'm not saying that they're not popular, but there's nothing in the Constitution that says, especially in the area of, like, say, reproduction, that there would be privacy rights. Uh, Justice Douglas called privacy an emanation of a penumbra of the Bill of Rights. Literally, this means that faint little darkened edge at the the very little bit where it's less dark at the edge of the shadow cast by the Bill of Rights. Um, and Now the Ninth Amendment says there are liberties that are not listed. So, certainly we could say privacy, it makes sense that we would have privacy rights. And so the Ninth Amendment might guarantee privacy. That's where I put the right to privacy in my list of civil liberties in the U.S. Constitution. Because the best defense is that most people seem to want to have privacy rights as they define them. And, Douglas invented them to justify the sale of condoms. And I think that it's pretty clear it'd be unpopular uh, for for it not to be protected, that people would have the right to contraception. This is a picture. You see at the very middle there, it's really dark. That's an umbra. The gray, not as dark part, that's a penumbra. The emanation of a penumbra would be any light cast off by the edge of the penumbra. So civil liberties are not just um, things written in a book, right? They have effects on public policy. In fact, if the Supreme Court's going to make a decision on a case, it's in order that government agencies and government decision makers are aware of what falls within the law or the Constitution. And so, it's important because where there are avenues to counter decisions made by the court, these often take a long time. There's been several constitutional amendments related to changing the former Supreme Court decisions. Ultimately, however, the court is limited just as all federal branches are. When the will of the people is strong and steady, it's likely to have an impact on policy, even that of civil liberties.